With the recent court rulings on election matters in Nigeria, the citizens are looking forward to more electoral reforms ahead of the next general election in 2027. In the past week, the Appellate Court has overturned the victories of 3 governors declared winners by the Independent National Electoral Commission, INEC, in the March 2023 election. All 3 governors whose election victories were overturned are from the opposition parties. Abba Yusuf and Nasir Garwa, the court nullified Abba Yusuf's win from the NMPP, declaring Nasir Gawuna of the APC as the victor. Similarly, the court in Zamfara invalidated PDP's Dauda Lawal's win, ordering fresh elections in 3 local government areas. The race mainly involves Lawal from the PDP and Bello Matawali from the APC. And lastly, the Appellate Court's decision to remove Governor Caleb Mutfwang of Plateau State, who secured 525,299 votes, and awarding the victory to Netanwe Goshwe of the All Progressives Congress, who garnered 481,370 votes in the March election. Joining us now on the show, as we look at the People's Democratic Party's position concerning the Court of Appeals decisions and ways to reform the electoral system for optimal result generating process ahead of 2027 election, is Daniel Bwala, spokesperson of the dissolved Atiku Abubakar presidential campaign during the 2023 presidential election. Good to see you, Daniel Bwala. Good morning, and thank you for joining us on the morning show.
Thank you. Good morning. Thank you.
Well, you had I'm sure, the introduction. Recent Court of Appeal decisions, the governorship election in Plateau, in Kano, and also in Zamfara State, with many concerned parties calling for a review of those rulings, where naturally the judgment, the outcome will go to the Supreme Court, as the aggrieved parties had said, and already the NMPP, in the case of Kano, has gone to the Supreme Court. Now, some other persons have said, in fact, the NJC should review the performance of the judges, particularly with regard to the contradictions seen at page 67 of the lead judgment by Justice Adumei in the matter of Kano State and all that controversy and protests, and all of that. What do you think about these rulings, this Court of Appeal rulings, and maybe generally, electoral jurisprudence as we have seen it this year?
Thank you. Thank you for having me, and good morning. Mr. Bati, since 1999, when we returned to democracy after a long time, in all elections we have had 1 or 2 judgments that were questioned by public opinion because the judgments were considered as inconsistent. But from 1999, there have been evolutionary development, if I have to use that word. But in 2023 elections, we've had the worst of judgments of court. We have not had so much of conflicting decision by one tier of government, because if you look at the election tribunal this year, you would notice that there were inconsistency in 1 or 2 tribunal cases at the trial level, and then probably at the Supreme Court 1 or 2 complained. But at the Court of Appeal is where almost all of these conflicting judgments that have so far been experienced. And for the records, the Court of Appeal is one court. So even if it were judgment delivered in Maiduguri, let's say division of the Court of Appeal, and it can be relied upon in Lagos as the court, the same court, not that you are addressing their lordships and saying, my lord, your learned brother in Maiduguri decided this. No, my lord, this court, because the court is one. And so surprisingly, you would think that the court should be abreast of the various judgments it delivered and be consistent in its judgment, especially when the judgments are founded on the principles of the law. Facts can differ, but the principle of law is constant. And wherever you turn, when the principle falls on a direction, the judgment has to be consistent and constant. But we have seen conflicting decisions of the Court of Appeal, especially where it affected the People's Democratic Party. And I'll tell you what, there was the judgment by the Court of Appeal in Plateau State that removed the governor. And the appellate court delved into the merit of a pre-election matter, and they said it also qualified as a pre-election and main election, and they delivered the judgment. The same Court of Appeal in Ebonyi State, the case of pre-election was canvassed. The Court of Appeal in Ebonyi said it's a pre-election matter, we do not delve into pre-election. In Benue State, pre-election matter was raised regarding form of INEC. The court in Benue said it is a pre-election matter. In fact, we are guided by the judgment of the Supreme Court. We stay constant in it. In all these places where judgments were delivered, either in sustenance of pre-election matter in tribunal or in the rejection of the pre-election case in tribunal, the beneficiaries have been the People's Democratic Party. Awesome. This is where the concern comes. But you see, Mr. Abati, Section 287 of the Constitution of Nigeria makes it clear the position of stare decisis and judicial precedent, that the judgment of the Supreme Court is binding throughout the Federation of Nigeria on all authorities and courts that are subordinate to it. In this 2023 election, the Supreme Court of Nigeria settled the issue of pre-election matter. In the case brought by APM, in the case brought by APC, in the case brought by Labour, where pre-election matters were canvassed and they were joined together with fundamental provision of the Constitution to suggest to the Supreme Court that this is so germane that you cannot close your eyes from it. And the Supreme Court made strong pronouncement, in fact with anger and vehemence, that anybody who is not a member of a political party, or even if it were a member of a political party, where the case border on pre-election, it cannot be brought that said party is a busybody. I have also heard, Mr. Abati, people said, but in 2019, in Yari's case, the Supreme Court sacked APC. Why is PDP crying? And they failed to realize that in 2019, apart from the fact that it was a decision decided on the old order of both the amendment to the Constitution and the Electoral Act, it was a case brought by a member of All Progressive Congress. It was intra-party matter. In this year, Supreme Court said, you are a busybody to try to question. In fact, they even said, even where the legality of what you are challenging is genuine, it falls short of two things. Number one, time required for the determination of the matter. And number two, the matter is not an election tribunal matter. If you look at Section 34, the grounds for which election victory can be challenged is clear. And you will see there is no disobedience to the court judgment as a ground. There is no even the issue, for example, in Plateau State, Mr. Abati, when they say there was no valid Congress, that they didn't even have a structure in the first place that will warrant for them to sponsor a candidate. What is the structure of a party as recognized by law, by the constitution of the parties, and by the various decisions of even the Supreme Court? The National Working Committee is the life, the soul, and the spirit of a political party. When you sue the National Working Committee. As long as the National Working Committee exists, even if there is no any structure at all in a state, it cannot give rise to the decision of validation by the court that there is no conduct of Congress. In the first place, even the order that they raised and said it was violated, the order was obeyed because the parties that were brought to the court that gave rise to that judgment were not the party that eventually emerged. Before the judgment, there was a new Congress conducted in which new persons emerged. But even delving into the merit, legality, or otherwise of the matter are pre-election, tribunal case have no business, according to the Supreme Court, to even delve into the matter.
Okay, Mr. Bwala. So like others are calling, you are calling also that this judgment should be looked into all over again. I want to also link this to what Justice Datijo did say while he was leaving the bench. Can you make a correlation between all of this and what Justice Datijo said?
You see, what Justice Datijo said is quite unconcise. The character of the dispute before the various courts may differ. Somebody may be challenging double nomination. Somebody may be challenging falsification of document. Somebody may be challenging the emergence of candidate not through a valid Congress. Somebody may be challenging the legality or otherwise of the member of that political party. All of them fall within the purview of the pre-election as clearly illustrated in Section 285, meaning that it is a dispute that arose before the declaration of the winner of election. Now, any dispute that arises in a political party, whether during the Congress or during the primaries, there is a time frame for the determination of that suit. And there is a forum which the law says it is the Federal High Court, both in the Constitution and in the Electoral Act, and not the Election Tribunal. The Election Tribunal, according to even Justice Datijo, is a sui generis. It is a different character. You do not equate the proceedings in Election Tribunal with the proceedings in regular court. An example, if in regular court you're out of time to file any document, and you can file a motion for extension of time to do that. If the other person files counter affidavit to challenge it, the court has always said that where there are two competing motions, the one that will survive that will survive the suit is the one they will consider. So they are always inclined to granting that motion. In Election Tribunal, if the time passes you, the time passes you. Even Supreme Court said they cannot exercise jurisdiction to determine the matter. So Justice Datijo made it clear that the character of a pre-election case, no matter the gamut in which it arises, can never be entertained by Election Tribunal or an appellate court that is determining the question that arose from Election Tribunal. And that is why you find in Benue, they maintain the position that they lack jurisdiction to determine pre-election. In Ebonyi, they maintain that they lack the jurisdiction to determine pre-election. Even in Plateau, they said that it is an election, although we admit that it is Election Tribunal, but we also believe that it is a pre-election because it borders on Section 177 of the Constitution. Now, Justice Nikki Toby and the various justices that have served and have retired have always in their judgment classified any decision by a court lower than them that tends to run away from their decision. It is judicial rascality. They say you are embarking on a frolic of your own because this Constitution, no Electoral Act, says in Section 287, the judgment of the Supreme Court binds all courts in Nigeria that are subordinate to it. And in this case, it is the judgment of the Supreme Court that said pre-election matter cannot be determined by Election Tribunal court.
Daniel Bwala, well, the reference to Justice Mohammed Datijo is not just about pre-election matters. Justice Datijo said a lot that politicians have been quoting to justify their contempt, if I may use that word, for the judiciary in Nigeria. Those points he was making about appointment of judges on the basis of nepotism, the point he was making about what he called the powers of the CJN, who is the chairman of the National Judicial Council and is the overall boss also of the other bodies within the judiciary, and also about judges that the public has misgivings about in terms of their integrity. Those were the more critical, weighty things that Justice Mohammed Datijo said. But that's not my question to you. If you want to address it, fine. But my question to you has to do with what is the way forward? Every election cycle, we have reforms. There is an agitation for reforms. Tomorrow, the National Assembly Joint Committee on Electoral Matters is calling for a conversation around matters arising from the 2023 electoral process that will require amendments to the Electoral Act and also to the Constitution, including this Section 285 on time limitation with election matters that you just mentioned, including diaspora voting, electronic transmission of results, electoral adjudication, and all of that. Do you think reform is the way forward and amending the relevant laws? And which laws do you think should be the main priority to be reviewed and amended accordingly?
Right, my bad. When Mr. Rufai talked about Justice Datijo, my mind went to the presiding justice of the Supreme Court that gave the lead judgment. I mean, the justice of the Supreme Court that gave the lead judgment. So I thought he was talking about the references, and he talked about a lot. In the case of Justice Datijo, who was retiring, what he did was to open up this country to the reality of the fact that the Supreme Court is as human as any other element and is also susceptible to corruption and corrupt practices. These were his words about the way in which people were elevated to the Supreme Court which are not consistent. Anything that is not consistent with procedure or law is corruption. So he was able to, for the people who said everybody should keep quiet when Supreme Court give judgment, he gave us a perspective that it is not all Uhuru. There is a problem in the judiciary and the system in which judges rise up to the Supreme Court, from recruitment and then promotion and all of that. So that's the point, actually. I didn't know he was referring to that teacher who was retiring. Now, with respect to the reform, and I have no doubt, Mr. Abati, in my mind that the Court of Appeal decision in Jos, when it goes to the Supreme Court, that like the way when we say all eyes are on the judiciary, the people tend to think as if you're blackballing the judiciary. No. When you say all eyes are on the judiciary, you are saying our hope now lies on how they will interpret. So this case of Plateau State, when it goes to the Supreme Court, it will be a case of Supreme Court versus the Court of Appeal. It has more to do with the sanctity and integrity of that Supreme Court itself. Because Supreme Court will have to determine whether that judgment they delivered in Presidential Election Tribunal is to be carried out by subordinate courts in Nigeria, because they made it clear, and a court, by a decision by a final court, is called a settled law. Once a law is not determined by the final court, it's not a settled law. But once it is determined by a final court, it is cast on stone. So Supreme Court will have to determine whether the Court of Appeal is above it or that it is above the Court of Appeal. With respect to reforms, Mr. Abati, in the last 9th Assembly, I serve as the person in the office of the Deputy Senate President. Of course, traditionally, that office handles constitutional amendment. And I began the process, and I remembered extensively the advisory we gave. In fact, the Deputy Senate President was open to some of these reforms that we introduced. We produced a bill. These bills were sponsored in the National Assembly, but as they began to go around Nigeria, some states knocked it down. We provided for pre-election. That is to say, time limit for which Congress matters should be determined and not brought forward to the primaries. Time which the primaries on has to stop, and then you go to election tribunal. So instead of pre-election and election tribunal, we provided for pre-election and then pre-election and the election tribunal, because we do not want a situation where somebody will win an election and then a court will remove him for whatever reason. So whatever question that arose from Congress must be determined before primary start, up to the highest court that has jurisdiction over it. Whatever happens in the election tribunal must be finished before the election. Whatever happens in the election will be determined by the election tribunal. If the 10th Assembly will go back into those reforms agenda, the reform agenda, and bring them forward, it will help. With respect to the Electoral Act, because what we did was, if you leave it at the Electoral Act level, what happened in 2023 will be applied. Where the lawyers and parties went about saying that electronic transmission is merely a guideline because it is not in the Electoral Act and it's not in the Constitution. What we did that time was to put it in the ground norm so that no court or individual can have jurisdiction to nullify it. If the balls, National Assembly will carry the balls to bring this reform, it will be helpful. Now, Dr. Abati, I am a human being. I must express my concern to say whether I believe this National Assembly will carry the reform or not. We will continue to suggest, but whether they have the balls is what I cannot guarantee you. This 10th Assembly is worse than rubber stamp. Rubber stamp is even better. Because in the rubber stamp assembly that was stamped in the 9th Assembly, at least they will deliberate, they will debate. At least they will interrogate the executive, but the executive will end up finding their way. Here, this one, they don't debate, they don't interrogate, they don't do anything. You heard from among their members, not external people, that when bills are brought to this house, the speed with which they are passed, and you know the bill passage process, you bring it to the plenary. When it is debated, you submit it to the committee. Committee will hold hearings. Then they will come back to their own committee of the whole before it gets to become. And the procedure for that is so that the Nigerian people will be carried along, because the law is made for the people, not the people made for the law. Okay. So reform agenda cannot be successful without removing the INEC chairman. Okay. Reform agenda cannot be successful without changing the INEC commissioners.
Okay.
Because majority of the INEC commissioners are members of a political party.
Okay.
And then lastly, all you need without doing extra work is go back to the 10th Assembly, 9th Assembly and pick the reform proposals.
We'll take a quick break and we'll come back to you. All right, so we have Daniel Bwala, spokesperson of the dissolved Atiku Abubakar presidential campaign during the 2023 presidential election. Daniel, great to have you back. Let's go straight to it. Like I was saying, I like to read the writings of Lasisi Olagunju a lot, of the Tribune. And he said something today in one of his editorials where he talked about the judicial adultery. I mean, talk me through this new phenomenon of errors in certified true copies and the judiciary itself. I mean, what's your take on all of this? And talk me through the counter judgments. Daniel Bwala?
Mr. Abati and Mr. Rufai, the sound is coming to me as noisy and echo. I couldn't hear anything you said.
Okay, can you hear me now? Is it any better?
It is backed up by echo.
Okay, so just if you hear the echo, just talk to me about the clerical error in the CTC in Kano judgments.
Okay, I think I heard something about CTC and Kano. I didn't hear the detail, but
Clerical
I did
error.
hear something like Kano and CTC.
Clerical error.
Now, in the yes, clerical error. You see, what happened in Kano is one fact that I will tell you today. Certified true copy stamp on a document is a conclusive proof in law that the document represents the character, the content, and it is from the original as cited. So usually, the reason why the court adopts of a CTC rather than original is because in these days of technological advancement, somebody can produce original from an original in such a manner that you may not be able to distinguish between the original from the original. But the CTC means it has to be stamped by the issuing authority as a conclusive proof. That judgment haven't been certified, whether by registrar or whatever, by that court, is a conclusive proof that the content in that document is true, it is final, and it represents the character. What is the character of that document? The judgment of the court in Kano. So where you saw in that document where it says, we hereby dismiss or appeal the appeal, the reliefs that supported the governor of Kano, in the eyes of the law, that is the judgment of the court. Because that saying, or that write-up, or that typo, or that type text was certified by the court as true, original, representing its character, and guaranteed that the content was actually what happened. So there is no way the Court of Appeal in this scenario will be able to walk back or withdraw from that. In fact, attempting to do anything to that document by that same court, it is attempting to relitigate the matter, because once the judgment has been delivered, the court is functus official. Now, the correction that is often referred to as clerical error that the judgment will give are corrections that were noticed and expressed by the court during the delivery of the judgment. During the delivery, if you can hear me.
Yes, sir. Yes, sir. We can hear you. Mr. Bwala, go ahead.
You can hear me.
Yes.
During the delivery of the judgment. So if, for example, as a judge, I am reading out the judgment. In the course of reading the judgment, I identify typographical error. In the open court, I will say there is a typographical error here. I will note it, and I will continue. When I finish, I have the right to correct.
I can hear you. We can hear you. We
It's
can
reconnecting.
We can hear you. All right, Mr. Bwala, we can hear you. You can just keep speaking.
I have the right. So if I'm delivering the judgment, I have the right to now, after the delivery of the judgment, correct the clerical error, because it was a judgment delivered to the hearing of the parties, a correction of which has been noted before the parties, But because it was typed and it's been delivered, or it was written and it's been delivered, that correction is observed. The court has the right to correct that clerical error and give it to the parties. But where a judgment is read without any problem to the hearing of everybody, without recourse or without prejudice to what the court said in that open court, because the conclusive proof that a judgment has been delivered is the CTC of the judgment being given. So some people have argued that everybody heard that the court trafficated right, but the delivery of the judgment shows that they turned left, and therefore it is what everybody had in the open court that is the judgment. When it was being read to everybody in the open court, everybody didn't have a copy. Like when you come to seminar, you hand everybody a copy. So they said what they said. The conclusive proof that that judgment is delivered is that that court will finally certify that judgment and hand it to the parties. So if the court made a mistake and hand it to the party, albeit the mistake that the court has made, that judgment becomes valid. In the same way that the court said the mistake made by INEC by not signing the documents that guaranteed the victory of that governor, that error cannot be accepted. You cannot approbate and reprobate. In the same way you rejected that because you felt that error is inconsequential. That is the same. That this judgment becomes final. This judgment represents the content. And without prejudice to what is read, when a judgment is read, it is at that ending part where the court makes that final declaration and grant the relief. That is the character, the soul, the spirit of that judgment. So in the eyes of the law, without prejudice to the clerical error as they claim, what was read and stamped, that is the decision of the court. So it will be interesting if they go to the Supreme Court. Let's see what the Supreme Court will say regarding 1, age-long principles of law about certification and the effect. 2, whether the court can deliver a judgment, certify it, issue to party, and then change its mind. And then 3, whether the legality or otherwise of a judgment is invalidated by reason of certification. So my humble take is that because of the plethora of decision of court regarding certified document, it represents the character, it is a true nature, and it is a conclusive proof of that document's authenticity, then it will be interesting to see what the Supreme Court has to say about that.
Well, Daniel Bwala, the view is increasingly being expressed that the judiciary has found itself in a quagmire with the handling of all these election petitions at both the tribunal level and at the appellate level. Now, what can we do to cleanse the judiciary? What should be the priorities going forward? Because we've been talking about electoral reform. How about the judiciary itself? In order to restore the trust of that common man that you refer to in the judiciary.
Well, the judiciary is often referred to as the last hope of the common man because over the years in Nigeria, even during the military era, the judiciary stood for justice to a large extent. They delivered judgments that didn't favor the military hunters. In fact, some of them, after delivery of the judgment, they came under persecution because they know that based on the principles of democracy, where you have separation of power, whatever dispute that arises from any question of fact or of law, it is the judicial branch of government that will finally interpret. And they know that they stood as the last hope for everybody. Last hope not just of the common man, but even the first hope of the strong man. Now, but over the years, we have seen that in land matters, in criminal cases, in all other areas, if you look at the judgments of court in a whole, they have been consistent from the trial to the appellate court and even to the final court. Only in election petition tribunal, only that we have this kind of contradiction, conflicting decision that now, as a lecturer, if I walk into the classroom, I find it difficult to tell the student what is the position of law regarding, for example, pre-election matter, what is the position of law regarding post-election matter, what is the position of law regarding validly nominated candidate, what is the position of law regarding disqualification. Because not the masses, not the lawyers, the courts have given various judgments. And in my view, there is need for the judiciary to have a thorough judges conference where I remember about 6 years ago where we said that with technology there should be a system of case recording and case storage where a judgment delivered by a high court, for example in Lagos, when you bring a matter before federal high court in Lagos, when you bring a matter before a federal high court in Maiduguri, the judge will be prompted by the system that there is a decision similar to it, and that judge will stay consistent with the decision of the Federal High Court in Lagos regarding the matter. And where he has to depart, then he will make it clear that there is a distinction in the character or in the fact of those cases. Now, in this time, Mr. Abati, even the court's attention have been drawn on so many cases as to the delivery of judgment by their brother judges. In some cases, even delivery of the judgment by the court above them. And they turn their back from it. And so it has brought a kind of disorganization in the administration of justice system in Nigeria to a point where the confidence of the masses is waning. Have you not seen a candidate that came second in governorship election in Kogi? He was asked, so are you going to court? And he stood a chance to invalidate that election. He said, I will not waste my time. Why did he have to say that? You see that the confidence of the people is gradually waning regarding the trust that they have to the judiciary. How can a court in Ebonyi, a court in Benue, and in all other places, they obey the judgment of the court above the Supreme Court, but in Plateau State, the Court of Appeal disobeyed the judgment of the Supreme Court regarding matters of pre-election. And before the Supreme Court, all characters of pre-election were brought. The one that border on double nomination, the one that border on certificate forgery, the one that on all characters, on even how somebody emerged from a party. And the Supreme Court maintained that position, and they spoke with vehemence. So it will be interesting to see how the Supreme Court will speak with the same vehemence they say about politicians and litigants, how they will say it about even the court below them. In the days of Honorable Justice Nikki Toby, they never failed to chastise the court below them, where the court below them disobeyed the judgment that they deliver, which by Section 287 says is binding on all courts below them.
Okay, thank you so much, Daniel Bwala, for your time. Thank you so much joining us from London this morning.